AI is transforming just about every sector. National security is no exception. What data the government gathers, how it's processed, stored, and used brings up a number of key legal questions, specifically questions around the Equal Protection Clause and the Fourth Amendment. That's why we're so lucky to have Laurie join us today. She worked as an honors attorney and assistant general counsel within the intelligence community from 2009 to 2013. Rest assured, we have a lot to learn from Laurie. Thanks so much for joining the show.
Thank you very much for having me, Kevin. It's a pleasure.
Well, as we always do with our Scaling Laws Academy series, first we're going to explore the fundamentals of the law, in this case, the EPC, as we may refer to it, and the Fourth Amendment in the context of national security investigations. Next, we'll see how AI amplifies concerns of bias and invasions of privacy during such investigations. And finally, we'll do a bit of exploring around what sorts of things we may want to see in this space going forward as AI continues to progress and as national security concerns continue to mount. So, Laurie, to start, let's just break down the Equal Protection Clause. What is it and what protections does it afford?
Sure. The Equal Protection Clause is found in the 14th Amendment, which came about after the Civil War. And it says that that no state shall deny to any person within its jurisdiction the equal protection of the laws. This is applied against state actors. And of course, we can also sue the federal government for equal protection violations. And in later cases, Bowling v. Sharp, the Supreme Court said that the Equal Protection Clause is read against the federal government through the Fifth Amendment Due Process Clause. So you can sue both the federal and the state government for violations of equal protection. And you essentially need to show that you have been discriminated against, that a law or a government action has discriminated against you. And the level of review that the court will apply to your Equal Protection Clause will be based on what type of discrimination is at issue. So the highest levels of review, strict scrutiny is what the court calls it, will be applied for cases of racial discrimination or discrimination on the basis of national origin, sometimes on the basis of alienage. When the court applies strict scrutiny, a law or action that the government takes must be found to be necessary by the court to further a compelling government interest. And if so, it will be upheld. Strict scrutiny is very hard for the government to win on. And the next level of review down, a lower level of review, is intermediate scrutiny. And this is applied in cases of gender, and sometimes it's applied, and it is also applied in cases of discrimination against non-marital children. There, the government action must just be substantially related to an important government purpose. So instead of being necessary to compelling, it's substantially related to an important government purpose. And finally, the normative basis for review, which most claims are reviewed under, is a rational basis review. And there you just have to have, the government just has to show that its action or its statute, its law was rationally related to a legitimate government purpose. Under rational basis review, the government almost always wins. It's very difficult to do otherwise, for the court to find otherwise. And the government attorney just has to show that there was some possible rational basis. It doesn't even have to show it was the actual rational basis for the action. To make things a little more complicated, however, and the way I think this will come up in AI, which we can talk about later, is that it's not enough to show that a action just has a disparate impact or discriminatory effect. So if you want to allege that you have been discriminated on the basis of one of these suspect classes, race, national origin, gender, non-marital child status, you have to show not only that that the law or action had a disparate impact, but also that the government intended it, that the government acted with a discriminatory purpose. And this, I think, will be where a lot of AI litigation may take place when we are trying to figure out whether algorithms that are discriminatory are purposefully discriminatory or whether it's just disparate impact. And I would argue that they are facially and purposefully discriminatory. But we can get to that later. But an example of that purpose, am I going on too long? Would you like me to cut there?
No, so I'll break it down for just 1 second. So starting off, it's really important to first just emphasize that we have to be thinking about an equal protection clause analysis from the perspective of these suspect classes, which in and of itself is a sort of sorting mechanism of saying, is this action being taken because of your race? Is this action being taken because of your age? That specification has to be made before we even begin to think through, okay, what's the tiers of scrutiny? Which level of scrutiny are we going to apply in this instance? And so when we move into the context of mass data collection and perhaps investigation by the government that may be aided by AI and facilitated by AI, how do you see that first initial inquiry of just identifying the suspect class? How do you see that manifesting in those circumstances?
I think it will be up to the litigants, and it will be very hard in a national security setting when everything is classified. Not only will some of the algorithms maybe be proprietary, but they might also be classified. What litigants claiming discrimination by AI profiling will need to show somehow, and it'll be very difficult, and I don't think that barrier is a fair one, but it will be very difficult for them to show, but they will need to show that the AI itself is somehow treating them differently on the basis of one of those categories. So it is, I don't know, a risk assessment that is used by a police department to pick which neighborhoods to do more police routes through, or which people at an airport to pull over for additional screening. You can see these things being selected potentially by things like race or religion or ethnicity. And that's the history of our nation. We've seen humans do it. If an algorithm is built on all this data collection, and it's we can kind of move into how bias is created in algorithms, essentially is what this really involves, is that they're trained on data, they're trained on human data, they're trained on decades of human data. And if there is systemic bias or racism in our society, which I think if you're not living under a rock, you will acknowledge exists, then that data will necessarily inform the AI that is produced by that it is trained on. So an example would be if you trained a bail or parole or sentencing algorithm, although I don't believe anyone's actually trained a sentencing algorithm yet, but they've used bail and parole algorithms for sentencing. But if you trained an algorithm on who goes out for parole, we have a lot of data in our that's been demonstrated that our criminal justice system has we, on the basis only of race, with all other things held constant, we people of color are subject to more arrests, more prosecutions, harsher sentencing, and knowing that those things are held constant, and so we understand that there's human systemic bias. That if the algorithm's trained on that data, the algorithm itself will produce the same results, and it'll just be an echo chamber, and it'll amplify it, because instead of being one human judge applying, or a jury, or biased person applying it, this will be just released across multiple systems, and it will amplify the bias and the racism. Or if you're talking about Muslim Americans being over profiled since 9/11, whatever category you wish, and so that's how I think it will play out.
And you noted that this is going to be a very difficult thing for a member of one of those suspect classes to even begin to raise just the showing of a disparate impact, especially in the context of national security investigations. So
yes,
can you provide a little bit more detail about why that may be difficult? What sort of discovery issues are they going to run into, even if they begin to think, maybe I just keep appearing on this TSA no-fly list, and I noticed that a bunch of other folks who share similar characteristics as me also are being held up at TSA. What's the
Sure.
next step, and why is that so hard, just with this initial prong of showing that initial disparate impact?
Sure. So I'll maybe do this in two steps. First, you have to show, as you mentioned, that disparate impact, and then you have to show that that is actually the reflection of discriminatory purpose. And the Supreme Court has said that it's not enough for the government to foresee a disparate impact. It really has to intend the disparate treatment. And the court has given us, in a village of Arlington Heights, they have given us, looking for the page, they have suggested that if a policy is so obviously discriminatory in its effects, then, and there's no other logical reason, then perhaps that could be considered actually rising to the level of facial discrimination, such that strict scrutiny would apply. And so the example that they give, the footnoted case in Arlington Heights, village of Arlington Heights, one of the footnoted cases, Yix Wu v. Hopkins, where essentially there was an ordinance that only people that you could only run a dry cleaning service behind a brick and mortar facade. It couldn't be a less sturdy facade. And although over 200 Chinese Americans applied for a waiver, none were granted it. And there was very clearly a discriminatory effect, and such that it looked like intent. So there might be ways to show that, if only Muslim Americans, or as we see, the watch list is predominantly, there's a lot of evidence, and Congress, has, members of Congress at least have written up, there's a lot of suggestion that the watch list is predominantly Muslim Americans and whatnot. So maybe if there's enough effect, you could show that there's actually intent. But in terms of, pleadings, and the second part of your question, I think, is you have to show standing. You have to show the injury. And the Supreme Court has jurisprudence. Clapper comes to mind. Another case, Zayden, comes to mind, where because plaintiffs didn't have access to a classified policy. In the case of Clapper v. Amnesty International, they didn't have access to how different electronic foreign surveillance was being implemented. In the case of Zayden, the plaintiffs didn't have access to supposedly a quote-unquote kill list about how drone strikes were being conducted. They couldn't show that there was actually a government action that prevented, that caused their injury. And so the court said, you don't have standing. You can't show that you have an injury against this government. It's too speculative. It's not concrete enough. Your harm is not concrete enough, so you can't sue. There are other doctrines. State secrets doctrine is rarely invoked, but that could come up. Classification generally, I think, just makes it difficult for folks to bring claims. There's qualified immunity doctrine, which essentially says that before a government officer can be held liable for actions that may have been discriminatory, it must be clear that not only was there a constitutional violation, but the law clearly established at that time that there was a constitutional violation. And so in the case of AI, where there isn't a lot of case law directly on point, it's going to be very hard for plaintiffs to show that biased algorithmic discrimination is clearly illegal. And that's why it'd be helpful if Congress would, pass some laws to that effect. But there are a lot of, another one is there are so many barriers, and I have a paper that goes through all of them, but at least many of them. It doesn't go through all of them, I'm sure. It's hard, as I've mentioned, to get injunctive relief unless you can show disparate treatment as well, and if you can show actual intent. It's also hard after the fact in any national security case any constitutional violation, any constitutional tort alleged against the government to get damages. And so it might be that in the moment you can't bring a civil case. You might be in jail, as in the case of Ashcroft v. Iqbal, or you might be held in jail. And so afterwards, if you want to sue for damages, because by now you actually have access to an attorney or you have the ability to bring a case, the court has all but shut down in the national security context any after the fact damages claims, which are called Bivens actions. And it has just said that national security presents a very special case where we're not going to allow after the fact damages unless Congress clearly intended it. And Congress has not clearly intended it.
Yeah, and I think it's important to flag that we're talking in late May 2025. There's still a lot we don't know about just how integrated AI is going to become into the national security context and the intelligence gathering context. We know that the OMB memo M2521 generally exempts the intelligence community from a lot of the more onerous procedural requirements with respect to using AI in high sensitive contexts or high impact use cases. We also know that there are huge incentives to using AI when you have vast troves of data, when you're trying to identify a lot of patterns. And I wonder, Laurie, if you could just touch on, with respect to that question of showing discriminatory purpose, how the sort of black box of AI, the idea that we can't tell definitively why one input led to a certain output, how might that be a sort of shield for the government if they are facing an equal protection clause claim?
The general idea is that oftentimes we know what inputs we give to an AI algorithm, we know the outputs, we have a sense of what the algorithm is, but since it's learning on its own and it's making connections, often based on correlations that the engineers didn't necessarily intend, so it won't necessarily, the cause and effect analysis isn't necessarily what the engineers intended. We don't know how the machine got to its answers. And so we don't know how the machine got to its output. So I can see in both the equal protection and in the Fourth Amendment context, the government saying, as you've suggested, well, who can be held liable? There's no purpose here. It's a machine. We don't know how it came to its conclusions. Maybe it came to its conclusions on a completely non-discriminatory basis. I think just before we even get into the law, I guess just as a matter of logic, that is very faulty. When the data that the machine is trained on is often represents so much bias, I think it's actually quite a fair conclusion to believe that maybe it was for faulty reasons. But what I argue in my paper on national security profiling is that one of the main arguments for using AI is that it's more objective. I think this is a faulty argument. I don't accept it on its premise, but it is, it's math oriented. It's data driven. It's data neutral. And of course, the neutrality of the data is what everybody hotly contests, as well as just the neutrality of whatever purpose the AI was designed for. It may be that you design an AI system for a purpose that is not entirely neutral, such as China flagging Uyghurs using AI. That's a much less neutral, or it's a much more sinister, awful purpose than using facial algorithms to unlock your iPhone. So there are many, many ways that AI can be biased and in sinister and discriminatory ways. So it will be difficult. But what I think is the response, and the civil rights advocates have made in various forms, and I think absolutely has to be the response, is you said this was data driven. So you should have records. You should know exactly what the inputs were and what the outputs were. Before you used it, you should have tested it to see if it was biased in its outputs. And I actually think we should look very much, and AI is tricky, but my gut instinct right now is that we should be looking very much at its outputs. And if the outputs appear to be discriminatory, it doesn't matter so much it does matter what went into the box, but the government knows what the outputs are, and they should be testing it rigorously before employing it. And if they decide to use it anyways, knowing that it's biased, when they do have the option not to use it at all and to go about things in a different way, that must at some level show some intent. And I'm up against some hard case law in this argument, the Washington v. Davis case law line of cases that, it's not enough to just foresee the consequences, you have to intend it. But I think given everything we know about AI and just how it has been shown time and time again to have biased outputs, to not only use it, not to tweak it, but you could tweak it, you could decide not to use it. There are so many options for the government that I think to go ahead blindly shows sort of a willfulness that I think could show some intent. And then, of course, plaintiffs can show too that if the AI is actually, before we even get to discriminatory impact and having to show purpose, if we can just show that the AI is facially discriminatory, if we go back a step in our analysis and say if it's cabining people by race or cabining people by religion, maybe you don't even have to show discriminatory impact and effect. You can just say it's facially discriminatory. It's segregating people the way that we think is unacceptable in other areas of law. It's not allowed in affirmative action to distinguish people on the basis of race. It's not allowed in segregation of housing and whatnot. This is doing that same thing. If we're taking a colorblind application which is the modern, the court's current approach is a colorblind application of the law. I don't buy it, but if that's what it is, then that's what the AI is doing. It's not being colorblind. It is discriminating facially. So I think that's the strongest argument, but you can also work with the effects and the purpose.
And just to carry this one step further before we head off to the Fourth Amendment land, which will be so easy to address. But with respect to the EPC, we also know that even if we find ourselves in strict scrutiny land, we then have to ask, is there this important and compelling government interest?
Yeah.
And one thing I could imagine as we see the policy discussions unfold in Congress and generally around the world, there's this sort of, well, if you use it, I'm going to use it. And as you mentioned, China is using AI in very oppressive fashions. And generally, we expect that AI is going to continue to be a core tool used by the PRC. And in this larger debate about AI, we've seen that this racing mentality of if China's doing it, then we need to be using similar tools. And this is a huge national security concern. And you can go on and on and on and see that this nexus with national security may become really paramount. So how do you see the current court grappling with the sort of broader national security implications of the AI race with China and other adversaries?
Well, that national security is always a very compelling interest. That said, in the history of strict scrutiny, it's been applied only in Korematsu, which the court has repudiated. But that national security imperative, I think, of course, the court is traditionally pretty deferential to in a variety of contexts. In SFA v. Harvard College, in the recent, not 2023, it's no longer recent, affirmative action case, Chief Justice Roberts did suggest that there were really only very limited, he mentioned a couple occasions where a racial category has survived strict scrutiny that are still good law. And one is, in dispelling prison riots, not dispelling, but preventing against prison riots, for example. And so national security was not one that he mentioned. I'll just say that. But stepping back a little bit from the case law, I think that as we try to compete with China, which of course we have to do, there was a paper that CSET, which is the Center for Security and Emerging Technologies at Georgetown, they put out a number of years ago. I want to say in the early 2020s, it may have been 2019 or so. Tarun Chhabra was one of the authors, but it was a whole host of authors. And it was a short policy brief, but it essentially argued that the ideology of AI matters, and that China and Russia had exported their AI to over 100 and something countries. It may have been 140, but over 100, we'll say, just to be conservative, countries. And the values are being exported with it. The values of whatever totalitarian state is programming its AI are being exported with it. So we want our AI, if we want to live in a world where the AI is somewhat protective of us, which I hope is possible. I'm not sure it is, but we have to implement our values into the AI. And so I think that actually suggests that the national security imperative is to have democratic, civil rights, human rights respecting AI. If we would like to preserve our way of life, that's our national security imperative. It's not to become Russia and China.
Well, clearly the equal protection questions are going to continue to be of incredible scholarly interest, and hopefully we won't find ourselves having to debate these too much with respect to real claims, and this will remain the land of scholarly inquiry. But leaving that aside for now, let's move into the Fourth Amendment. So again, if you could just help us remind everyone what exactly the Fourth Amendment protects in this general realm of thinking about AI use for national security investigations.
Okay, sure. So at a very high level, we'll start with the Fourth Amendment. The Fourth Amendment, which one of my colleagues says every national security lawyer should have memorized, I'll be one of those who hasn't memorized it, is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And I'm going to pause and say that's the reasonableness clause, shall not be violated. Well, the whole thing, the right to not be to be secure against unreasonable searches and seizures shall not be violated. That's the reasonableness clause. And no warrant shall issue, but upon probable cause, supported by oath or affirmation. And the idea here is you're going to a neutral magistrate outside the executive branch. You're going to the courts to have a second branch, make sure that the search or seizure is valid. So the no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched or the persons or things to be seized. And that second half is the warrant clause. So the Fourth Amendment has both a reasonableness requirement and a warrant clause requirement. The warrant clause is often it's now sort of the exception to the rule that a warrant is required. There are a ton of exceptions in the case law for the warrant requirement. For example, in traditional law enforcement, searches incident to arrest, automobile searches, et cetera, you don't always need a warrant, stop and frisks. In national security world, there's a special needs exception for reasons other than law enforcement purposes. If it's to protect health and safety, there might be a special needs exceptions. There are exceptions at the border where you don't need a warrant for a lot of searches at the border. And there is potentially in national security it's an unresolved issue whether there's a foreign intelligence exception to the warrant clause. All this to say, searches still have to be reasonable. So now we can leave it with reasonable, with sometimes a warrant requirement.
Okay, so we've got this warrant requirement that's kind of hanging out, and as every JD can probably remember of having a flashcard for their bar prep that has way too many exceptions being listed.
Right.
So we'll leave that for another podcast.
Right, and perhaps I shouldn't have detailed all that. But on the reasonableness side...
Excellent. It's excellent.
Okay.
Yeah. Just to now frame it up with respect to a sort of national security investigation, I think when a lot of folks have the Fourth Amendment come to mind, they're thinking, oh my gosh, the government's showing up on my doorstep. They're bringing the door open. They're rifling through my cabinets. Maybe they're thinking about a Kylo situation where law enforcement's using some
sophisticated
heat detector outside of someone's home to see who's in which room and all those things. What is the sort of hypo that we can think about for a Fourth Amendment claim to be brought in the AI context of national security investigations?
Well, I think there are many. Some that might... One of the ones that I've been thinking about is if the search or seizure is based on, biased AI. So if it's a profiling type. Another area altogether different would be under the third party doctrine. Much of national security Fourth Amendment jurisprudence takes place under the third party doctrine, which essentially says that if you have voluntarily surrendered your data to a company, such as an internet company, then it's no longer a search. There's no invasion of your privacy. A reasonable expectation of privacy is the watchword or the watch phrase. And your data is free for the government to order the company to provide. And the Supreme Court in 2018 decided a case called Carpenter. So on the third party realm, and said, and maybe tried to walk that back a little in terms of huge new technologies there with cell phone location, the cell site location information. And the court said, if we can have, this almost ubiquitous, omnipotent search capabilities, maybe we do need to have a warrant. But the court in Carpenter accepted national security cases. And so in national security, it still seems like free reign for all sorts of data collection can be provided to the government. That's one area. That's one area of national security. On the sort of profiling and bias side, I would flag a doctrine which is under the 1996 case Wren, WHREN, where the court said that if an officer's, even if an officer is actually stopping someone or searching someone on the basis of race or some other illegal basis, discriminatory basis, if the officer can also provide an objective basis, the court will not second guess it. And so the only way to pursue discriminatory profiling claims is via the Equal Protection Clause, and that has all the problems we just discussed. So it's a hard hurdle. That case has been very much objected to over the years by civil rights advocates, but it's good law. And so I think that AI advocates are going to have to argue, and I detail my own arguments for how the Wren doctrine shouldn't apply in the case of AI in my paper, but they're going to have to argue that the Wren doctrine does not apply to algorithmic searches and seizures, or searches and seizures based on algorithms.
Because I wonder too how you would tackle the difficult question of reasonable expectation of privacy, which of course we've seen is something that adjusts over time. It's very contextual. Yeah. It adjusts based off of new technologies, based off of new social norms. And we exist in a world in which some of these AI companies have scraped the entirety of the internet. When I talk to some students, they say, yeah, my info, if I can exchange my information for a free service, I'm all for it. Who cares? It's out there. Everyone's seen everything all the time, everywhere, all at once. How do we think about a reasonable expectation of privacy in these contexts, given that there's so much, the social attitude of data privacy is changing, and the access to data is obviously so pronounced?
Okay. I think that it is a very difficult question. My students also seem to have surrendered. Sometimes I even, I'm very security oriented, and I sometimes at some level surrender to it. The one thing I think we need to bear in mind is that the government still has tremendous power. And the reason ultimately that, government, at least in today's world, maybe this will change, but at least right now, it's the government who can put you in jail, not the companies. And so whether or not we get through a reasonable expectation of privacy tests, or I think Carpenter is correct in trying to apply warrant requirements more broadly. I'm hoping that's the direction the court will go. There's just an increasing desire for warrant requirements, and being the default, the government's enforcement power is ultimately what the Fourth Amendment protects against. It protects against that, and your right not to be thrown in jail, but also your right to free speech. The Fourth Amendment is a bolster for the First Amendment. It's ultimately a bolster for free in democratic society. So I think we need to think hard about not necessarily just giving free rein to the government for all of our data, even if we've taken too light of a look at giving it up to companies. And I think students and all of us should be more careful too in what we give up to companies. And we should insist on companies not sharing everything. And we should insist on AI companies, not data mining copyrighted information as well as all of our personal information, I say as a wannabe writer. So I think we just have to insist a little bit more.
Yeah, and there's certainly so many threads to pull on there, but we'll instead just focus on a couple of other threads. So as I mentioned earlier, we're talking in May of 2025. There's a lot of uncertainty right now about AI policy. There's a lot of uncertainty around how these doctrinal concepts, which have a lot of history and yet are still laden with ambiguity, how they're going to evolve. So if you were to sit down, Laurie, and kind of write out a treatise of what you may like to see, or some things that you may like to be given greater prioritization or emphasis, what's near the top of that list? Or what are some of the things you're thinking about these days?
Well, I think that anytime I've been focusing on government use of AI, so I'll cabin my remarks to that. I do think that anytime the government wants to use AI, it should do risk assessments. It should go beyond. You mentioned the recent OMB memo, which only applies, not to national security folks, but nor does it apply to anything other than high impact AI. It should apply to all AI uses. That memo has rescinded some of the there was a lot of language in the previous Biden administration memos about testing for algorithmic bias and whatnot. That language is completely gone. It does suggest that agencies should make sure that AI doesn't violate non-discrimination laws, but I think there should be rigorous testing requirements for bias, for profiling in AI before it's released and after it's released. Agencies must be continually monitoring it. But it can't be just on government attorneys, because I used to be one, and I think that would just be an enormous burden. So we also so those are front end fixes, but on the back end, we have to have sort of a reinforcement loop. And that means that Congress needs to pass some legislation. And I know that's pie in the sky, but ultimately, in an ideal world, there would be just legislation saying that you could bring a disparate impact suit. You don't have to show disparate treatment, or you don't have to show purpose, just disparate impact causes of action for government use of AI. And there should be, Congress should take up the court's sort of insistence that Bivens doesn't apply in national security settings and say, well, guess what? There are causes of action for damages, for civil damages against government officers. We need some accountability for using any sort of discriminatory AI. So I think Congress should do some work in that regard. I also think that it would be nice to have, in the way of, we have a FISA court to do some oversight of FISA surveillance. It would be nice to have a court, and whether an Article 3 court or whether just an executive, there's a new data protection review court that's sort of within the executive, whether it's that type of court right within the executive branch, to do some out-of-agency review of the AI before it's deployed. I think that would be another good fix. And I think the courts should rigorously apply these doctrines that we've been talking about. I hope that they will find that there is intent often, and we have some good cases pre-AI that suggest some courts willing to find that discriminatory purpose, such as Hassan v. City of New York and the Floyd case out of SDNY. And I hope that they will apply the Fourth Amendment reasonableness clause rigorously and find that sort of openly discriminatory profiling isn't reasonable. And the details of my arguments I've written out, but that's where I'm at. Thank you.
Well, Laurie, you have quite the ambitious research agenda to get back to. Lots of open questions for you to address. Thank you so much for sharing your insights with scaling laws, but we'll have to leave it there for now.
Thank you so much. Appreciate it.